Good afternoon, everyone. This is Eric Morehead from Morehead Compliance Consulting, and welcome to our webinar, Training Your Board of Directors on Compliance and Ethics. I appreciate you all taking the time out of your afternoon to join us. And we're going to spend the next hour talking a little bit about training your board of directors on compliance and ethics and their responsibilities for compliance and ethics, and some suggestions that I've learned over the years that might help in this process. A little bit of background about myself for those of you who don't know me. I have been working with organizations, either resolving internal issues, looking at their compliance programs for the last 17 years, both as outside counsel. I spent a few years working at the U.S. Sentencing Commission on general counsel staff, uh, and uh, uh, and in the last few years, I've been working mostly with organizations that are trying to be a little bit more proactive about their approach with regards to their compliance program. And I hope that's the situation that most of you find yourselves in these days. Um, I've been presenting to boards, training boards, working with executive committees for almost that entire time. Back when I was in private practice, most of that interface had to do with presenting results from internal investigations and that sort of material. But in the last few years, been spending more time training boards of directors on specific compliance risks, talking to them about their responsibility for compliance. And on a personal note, I have 3 kids under 7 who are expert campers. This is a picture of Rosie, our youngest, who has been dubbed the nighttime menace by her older brothers when we do camp. This is a picture of her just actually this last weekend where we were camping together. I want to break this down into a couple of different sections over the next hour, and some of the things that we'll be talking about is first and foremost, what does effective compliance training look like for your board of directors? What are the expectations, both from a legal standpoint? We'll look at the sentencing guidelines and other legal standards, guidance from the Department of Justice, including some very recent guidance that helps us determine what effective training looks like at the board of director level. We'll talk a little bit about the business case for effective compliance. I think that this is something that ought to be integral in your approach to training the board of directors, talking to them about what's often called return on ethics, ROE, or the business case for investing in compliance and ethics and culture at the organization. I think that can be extremely effective, not only for them to understand the importance of it, but also would hopefully dovetail with other initiatives that are ongoing in the organization. And I think this is something that's sometimes left out when communicating to the board directly, certainly in a training context, giving them some background and data around the business case. Talk a little bit about how what you should be presenting to the board about your program specifically. What kind of metrics would you want to present to the board of directors? What kind of information should they be receiving? What should that interface look like? What kind of questions should they be asking? That's an important one. We'll talk a little bit about risks that are specific to risk training that's specific to the board of directors. This first bullet may be familiar to some of you who have been familiarizing yourself with the most recent guidance from the Department of Justice. What is a manifested risk? That is a term that is going to become more and more common as we move forward, because that's the way the department is now talking about risks that are apparent risks and how your organization ought to be handling discussion and training around those things. Benchmarking is a piece of the puzzle there when you're talking about specific risks. And then lastly, I'm going to spend a few minutes at the end talking about creating and maintaining a strong relationship with the board outside of formal training. When we talk about training the board, I think what comes to mind for most of us is putting together, not unlike this presentation that I'm delivering today, a PowerPoint presentation, having very specific messaging, going in, having a dedicated piece of time, whether it's 15 minutes, 30 minutes, 45 minutes, if you're lucky, an hour, to actually talk with the board directly about a specific issue. But training for the board on compliance and ethics is much broader than that. I think there's an informal component. I want to talk a little bit about that as well. So first, the first big piece of the puzzle is the board really needs to understand their duties and the expectations of regulators, the expectations for the governing authority of the organization to have oversight for the program. There are some components to that that I think are worthwhile. Not only training new directors. I think where this often happens is there, particularly for larger organizations, there may be an onboarding process for new directors, and part of that will be a module or a piece of the puzzle that includes talking about their role in oversight of compliance, and then it never gets discussed again in the regular course of training or communication with the board of directors. I think that's a mistake. I think that this is something that is, as we have seen with recent guidance that just came out in February, this is a moving target to a great extent. So I think this is something that should be revisited with the full board on a regular basis, talking to them about their responsibilities. The some of the bigger pieces that I would include in this discussion are their legal obligations, for example. If you look at the ABA model, Business Corporation Act, or the local state corporation act, or a regional, if you're in a foreign country where your organization is incorporated, there are some pretty strong consistencies between what you see in the ABA model, and that's what I'm going to be quoting here in the next minute or two, and what shows up, and what are the expectations for directors with regards to oversight from state to state. The basic responsibility is that a director has to act in good faith, and they have to act with care. And that care would be what an ordinarily prudent person in a like position would exercise. So the key component here is acting in good faith and acting with care. And if they do that, the carrot here is that a director won't be liable in any action if they have acted within that duty of care, if they have acted in good faith. More and more often, particularly in the last 5 to 10 years, directors are rightfully concerned about personal liability. And so one of the things that can be pointed out to new directors or directors that are going through training is that in the effort to try to limit their personal liability, it includes acting in good faith and acting with the duty of care. Well, what does that mean? Acting with the duty of care means understanding the business, understanding the issues before the board, being involved, asking questions, acting when they need to act based on the information they have, and then getting expert advice, both from internal experts or, as it may be, external experts when needed. So it's a give and take at its bottom. It's making sure that the board is educated about everything that's going on with, for instance, the compliance program. They need to understand all the big pieces of the puzzle, and we'll talk more about that in a few minutes. I think in the past there was this notion that the compliance program existed, that the compliance officer or the persons responsible with the program would come and report to the board on a regular basis on how things were going at a very high level. I think that if you look at the expectations as they've evolved over the last few years, you need a board of directors that actually has a little bit more granular understanding of the program beyond just a general update. And we'll, again, talk more about that in a few minutes. When you drill down and you talk about care, the duty of care in the compliance context specifically, I think that's, again, the kind of the two main points here are being informed about what's going on and being proactive in asking questions. If you have a board of directors that doesn't ask a lot of questions about your program or doesn't ask any questions about your program, I think that they are in danger, depending on the context, of not meeting their duty of care. Another concept that is important for them to understand, and many of them already do, again, since the focus on personal liability has been great in the last few years, but the responsible corporate officer doctrine here in the United States has been developed through case law over the last half century, really focuses on the authority, the position of power that the board of directors holds, that they have the power to potentially prevent a violation or misconduct from occurring, and they fail to do it. So it really, it's a criminal potentially extension of the duty of care that we were just talking about. Again, I think that when you talk to members, when you talk to directors, when you talk to boards these days, they're well aware of their personal liability and this to a great extent. But for newer directors or directors who perhaps have not haven't had regular training the last few years, it's worthwhile to come back and discuss it. There's no duty to be right, however. Liability doesn't attach to the board or to the individual directors if they are acting in good faith, if they are acting within their duty of care. Now, another case that I think is important to bring to their attention if they aren't already familiar with it is the Caremark case, which is a Delaware case going back a few years, which really zeroed in on the responsibility around compliance. It established that there was a duty for the board, specific duty for the board to oversee compliance. Now, it's important, I'm going to mention this a couple of times, it's important to understand that this is a duty for the full board, not just the audit committee of the board of directors or your compliance committee or whatever subdivision you may be more frequently visiting with. So when we're talking about training, we're talking about training the full board and educating them about their responsibility and oversight as a full board, not just a subdivision that has the specific responsibility, such as the audit committee. The case was further developed a few years later with Stone versus Ritter, where the oversight of compliance was honed a little bit more to talk about some specific pieces of the puzzle, and that included designating staff such as a compliance officer or resources for the program, that the board was also responsible for training, the written policies of the organization, and it spent some more time really talking about oversight, that give and take, asking questions, being knowledgeable that we were talking about. So it's important for them to know that there's an expectation out there in the case law that they're going to be familiar with sort of the big ticket items of your program, that they're going to understand that there is, for example, an annual online code of conduct training, and they need to be familiar with, generally speaking, with what the content is. And we'll talk more about that specifically later. When it comes to written policies, code of conduct, most organizations take the time to have the board review and approve major changes to the code of conduct. But the Ritter case and other guidance that we've seen over the last few years is not necessarily specific just to the code of conduct. So there ought to be a general understanding about what is happening with the written standards that the organization is employing for employees and stakeholders out in the field. Do they, if, for instance, if there is a recently developed policy portal, has the board been given a demonstration of that policy portal, and do the board members have access to that policy portal? Things like that, really need to be considered. And they, again, in training, need to be aware of their responsibilities. Another big piece of the puzzle is obviously the sentencing guidelines. The guidelines, as many of you know, are have just celebrated their 25th anniversary. The sentencing guidelines for organizations were first promulgated in 1991. They apply to all organizations, whether you're a nonprofit, a university, NGO, corporation incorporated in the United States or anywhere in the world. And they've sort of become the basic standards for effective compliance programs, both here in the United States, but they've been adapted into other standards throughout the world. I'm not going to spend a lot of time talking about the guideline standards. Many of you are already familiar with that, but I did want to talk a little bit specifically about where the guidelines talk about the board. And the guidelines, again, recommend that an organization's governing authority be knowledgeable about the content and operation of the program and exercise reasonable oversight. So again, if there's two prongs here that I'm going to beat into your head for the next couple of minutes, and that you ought to focus on with the board of directors, it's this knowledge of the program, knowledge of the resources involved, knowledge of the moving pieces, and exercising oversight, asking questions, being proactive. That is the expectation. The 2010 amendments, it's important to note, I wanted to throw this in here, that the board understand that the 2010 amendment to the sentencing guidelines really emphasize the importance of, I say CCO, but as many of you know, the guidelines don't designate a compliance officer. They talk about the person or persons responsible for the program. So that might be the general counsel, it might be the chief auditor, it might be the HR director, depending on your organization. The person responsible for the program has to have access to the governing authority, the board of directors, whenever there's an issue of at least the minimum threshold is criminal misconduct, and at least on an annual basis to talk about the operation of the program. So the very basic minimum requirements from the sentencing guidelines for that, the relationship between the compliance program and the person or persons responsible and the board is at a bare minimum, they have a conduit to the board if there's misconduct, and on an annual basis to update the board on the program. Obviously, best practices are greater than that, but that's the bare minimum. The board also is responsible, it's mentioned a couple of times prominently in the guidelines, about promoting culture that encourages ethical conduct. And we'll talk more about the culture piece as we move along. But that is another important piece to point out to them with their responsibility. It's not just understanding the legal programmatic aspects of the program, the controls that are in place, training, written standards, these big picture technical pieces of the program, but it's also a responsibility for the culture of the organization. And that's baked into the sentencing guidelines. The last thing I want to point out from the guidelines, and this has to do with training, is that this is where the actual requirement of the board being trained comes from. The organization shall take reasonable steps to communicate periodically. So we don't have anything more formal than periodically, but periodically for most organizations means on an annual basis up to every 2 to 3 years at the most. I think most organizations are training their board pretty frequently, maybe even more often than annually, and breaking this up into different pieces. But the training has to talk about the standards and procedures of the program, of the science program, and it has to be disseminated to the governing authority as well as the rest of the organization. The guidelines very specifically state that the board of directors, along with everyone else in the organization, needs to be trained on the program and the roles and responsibilities. And then more recently, we've seen some more guidance coming from particularly the Department of Justice. The Yates Memorandum, the one thing I wanted to point out here is a lot of discussion a lot of discussion around Yates has been specific to talking about the responsibilities and potential liability, in fact, of compliance officers. But I think it's important to think about how Yates talks about the necessity for a clear plan to resolve individual cases. That could mean liability for board members as well, not just corporate officers or a compliance officer or managers or others who were the bad actors or potential bad actors in any misconduct. That individual can mean anybody within the organization, including the board of directors. So the Yates Memorandum, I think, has some applicability to the board when you're talking about that issue. And a little bit of data here. This comes from the U.S. Sentencing U.S. Sentencing Commission statistics over the last few years. You can find that data at ussc.gov if you're interested. If you look at organizational cases, this is something that people have been talking about a lot since Yates came out. you'll see that in the majority of cases, 60% of the cases over the last few years, this is 2014 and 2015, we don't have the 2016 stats just yet, uh, there's at least one individual co-defendant that is caught up with the organization. And what's interesting is if you hone down on that, about half of those people are not high-level officials, but a good percentage are board members. Again, this might be illuminating for board members to understand when you're discussing with them their responsibilities. That a significant number of board members in 2015, 21%, 20% of the individuals, the actual humans that found themselves being charged along with a company for a violation of federal law were board members. Now, granted, a lot of these organizations were smaller organizations, so the board members had more hands-on in the operations of the organization, and those board members might also have been officers. But it is perhaps an eye-opening statistic for some board members to consider when you're talking about potential liability. Other guidance that's come out, the DOJ and SEC FCPA guidance that's came out in 2012 that we've been talking about for the last few years reinforced what we heard from the sentencing guidelines and what we've heard from case law over the last, going all the way back to, if you're looking at the responsible corporate officer doctrine, the last 50 or 60 years, this notion that the board, along with senior executives, set the tone and they're responsible for compliance. It starts at the top. And then the last thing that I wanted to talk about in this legal piece, the responsibility piece, is something that's just happened in the last couple of months. If you're not already familiar with the evaluation of corporate compliance programs, it's kind of a prosaic name for a new memo that came out. Here is the web address for it, if you would like to take a look at it. It's not a very long document. It's about, I believe, 6 or 8 pages long. It came out just 2 months ago, and it talks about all aspects of a compliance program that the Department of Justice will look at when they're evaluating effectiveness. But I wanted to talk specifically about where this document discusses the board, because it does. And there are some very interesting pieces, and this comes directly from the guidance. The first and probably most interesting is uh, one of the inquiries that the Department of Justice says that they're going to make if they're looking into the effectiveness of your compliance program at your organization is, quote, what compliance expertise has been available on the board of directors. That's a direct quote, by the way. I didn't put quotation marks around it, but that's a direct quote from the guidance. So you can expect, your organization can expect that a Department of Justice trial attorney or a assistant U.S. attorney from a local U.S. attorney's office that's in potentially investigating some misconduct that might rise to the level of being an offense might ask, what is the compliance expertise on your board of directors? Well, unless you happen to have a board of directors that's comprised some or all of former compliance officers, which is not very common, then you have to develop that expertise at the board of directors. So I don't think there's been a more direct admonition in the last few years from the department that we ought to be training our board of directors on compliance and ethics, because there's an expectation now that they're going to have expertise. And they're not going to get there unless there is regular, periodic training on what the expectations are and some of these other pieces that we've been talking about, including specific risk training, risk topic training. The second query that came from this new guidance is has the board of directors or external auditors had private sessions with the compliance and control functions? I think this just builds on the guidance that we were talking about a couple minutes ago from uh, the sentencing guidelines about this special relationship that the person or persons responsible for the day-to-day operations of the program, or whether that's the chief compliance officer or general counsel or someone else, has a conduit for meeting with the board of directors. Now, this is, again, this is not specifying the audit committee of the board of directors. This is talking about the board of directors. So Again, the training of the board of directors gives an excellent opportunity for that relationship to exist, for that box to be checked, if you will, that the compliance officer, the person responsible for compliance, has had that executive session, has had the ability to discuss these important issues with the board directly. And then, again, a reiteration of many of the topics we've been talking about for the last few minutes. What kind of information does the board have, and how have they exercised their oversight? So no surprise there. I think the biggest change here, or the biggest eye opener, perhaps, is this notion of expertise and develop. And again, unless you happen to have 12, you have a board member, a board of directors that has 12 compliance officers, former compliance officers on it, then you're going to have to develop that expertise. And the way to develop that is through training. The next big piece of the puzzle is I think talking a little bit about getting the board to understand the business case. This is something that I think is not often discussed at the board level, but I think can be really important. And I'm not going to spend a whole lot of time going through some of the, there's some data that I have in here. These slides, as has been mentioned in the chat function, will be available afterwards. If you've got questions afterwards, you can always direct them to me or to Morehead Consulting, and we will respond to you. But there's a lot of material you could potentially cover in this area, and I'm just going to touch on a few things. And again, to me, if beyond the basics that we just talked about, the basic responsibilities that have to be explained to the board, the next most important thing to me is making the business case to them so that they understand the importance of the compliance program and how it affects the organization's bottom line. And then they can, then that's going to affect all the other decision making and communications that they have with the executives of the organization and everyone else. It's indoctrinating them, getting them to buy in to the business case so that they can then cascade that message onwards. There are different areas, different metrics that have been developed over the last few years. CBM a few years ago, or CEB rather, a few years ago had a metric on the relative stock performance of organizations that were perceived to have a strong ethical culture versus those that did not. Ethisphere Institute, many of you might be familiar with, also has compared the relative stock performance of organizations that have received the world's most ethical designation versus those that have not. So there are some stock performance metrics that are out there, but broadly speaking, I think that if you're going to look at ROE, I think that what you might want to start considering is, what can I find internally? What are some internal data points that we can point to that show that we're getting results, bottom line results, based on the investments that we're making? One thing you might look at is if once you've been communicating to the employee population about the importance of speaking up and making reports, if you've seen a noticeable jump in reports. So you can show that your messaging around a very simple and specific initiative has results. I think if you're showing ROE, you can show some general statistics that are available out there about performance of organizations, but really, ultimately, you'll want to try to gather some internal data and think creatively about how you might do that. And a lot of it is going to be based around initiatives, but also you might, for instance, if you've been training on data privacy, for example, and you've had over the last 3 or 4 years, maybe like 2 or 3 data privacy breaches. Well, you can quantify probably pretty accurately what the financial impact of those data breaches has been. And if you train on data security and data privacy issues, and you really hit on that over a period of 1 year or 2 years, and you have no further breaches, then you can go back and show, here's what we lost. Here's what the actual, down to the cent, what the costs were for, just one data breach that we had during this 18-month period. And since we've refocused and and messaged around this, we haven't had any further ones. So, I mean, those are the kind of things that I think you want to talk about, and you want to talk about it to the board of directors as well. Reputation issues. This is another one. Again, it's a little bit harder to quantify, although in the case of United Airlines, it was pretty easy to quantify over a couple of day period where they lost about $1 billion in equity, although they seem to have bounced back somewhat since then. But again, I think that's, things like United Airlines, like Wells Fargo, can show the board of directors and any audience for that matter how quickly those sorts of compliance failures can impact the bottom line. Recruitment and retention. This is another area where you can potentially show the board some data, both externally and internally. This is a survey that's been around for a few years now, since 2008, but it's a good one. There's a couple other data points that have been out there for a while. The bottom line here is that whenever there's a survey or a study that looks at this, there is an impact to having a strong ethical culture on recruiting and retaining strong personnel. There is also a lot of literature out there about how this is also potentially a generational issue, that millennials, more than Generation Xers like myself and baby boomers, are interested as a top tier issue when they're considering where they're going to go to work, on finding out more about the culture, and having an ethical culture is a top tier issue for them. So things like that, data like that, I also think can be important to present to the board around the business case program. Observance of misconduct, the likelihood of employees leaving based on misconduct. It really depends on how they're treated. Those who are retaliated against, no surprise here, I guess, are likely to leave within 2 years. A much smaller number, even though they've observed misconduct, if the culture's strong and retaliation is not allowed, they stick around. Again, data around things like retaliation numbers, retention numbers, this can all be very helpful in making the case for the program and explaining that value to the board. Compliance also can be a career development issue. Managers, the people that you're really trying to groom, to promote, to be the leaders of your organization in the future. Again, if the culture has some issues, and retaliation often rears its ugly head when ethical culture is not strong, they don't stick around. And managers, this is something that I think when we talk about retaliation, we often think about the rank and file members of our organization, but it affects managers as well. 22% of managers from the Ethics Resource Centers or Ethics and Compliance Initiatives study from 2015 stated that they had experienced retaliation. That's a pretty high number. Getting and retaining top managers so that they can lead the corporation in the future is really important, and that's an issue that I think that will really resonate with the board. The reporting, again, these things are all very logical. Reporting in organizations with a strong culture is way up, so you're much more likely to catch those issues, much less likely to have that whistleblower that nobody wants if you have a strong culture where people are comfortable coming forward. And as I already mentioned, when you're talking about these issues with the board or any other audience, it's helpful to talk about Wells Fargo. It's helpful to talk about the issues that United has faced over the last few weeks. These are all things that are going to be resonating with them because they're thinking about them and how they would react if those sorts of situations would happen within the organization that they sit on the board of. Some lessons from Wells Fargo, I think that are important to talk about with the board if you're talking about these sorts of reputational issues. Sophisticated controls, don't necessarily catch everything. Incentives matter. And there was, according to a lot of the material that's out there about the issues that happened, there were some perverse incentives that perhaps spurred some of the conduct. The employee perception of culture impacts reporting. There were a lot of people who knew about what was going on at these branches throughout Wells Fargo, and they didn't speak up. And so culture was a key issue here. And it's very easy for an organization to have the disconnect between the upper levels of the organization and the ground level around culture, because we heard John Stumpf and many of the other executives from Wells Fargo testify on Capitol Hill and make statements otherwise. They felt that the company had a strong culture. And as I've often said about this issue, I think, let's take him at his word that he really felt that way. I don't necessarily doubt that, but there was a disconnect because that wasn't what the people on the ground felt. So these are all important culture messages that weave into this business case and weave into, I think, an important piece of the puzzle, the culture of the organization being discussed and information provided to the board of directors on that issue. Obviously, you want to also not just dwell on Wells Fargo and United and all the other myriad of failures, because you could definitely spend all day just talking about that. But you want to talk about the things that are positive. Organizations, again, that have a strong culture see less misconduct. If the perception of the culture is strong, the actual observed misconduct goes way down. If you have a strong program, there is less. There is a strong correlation between a strong, well-implemented program and a strong ethical culture. So they support each other. You can't just have a culture independent of the controls and the processes of a compliance program. Another issue that is important to talk about, to train the board on specifically, is your program. I already talked about the fact that the expectation from many regulators out there is that the board is going to be familiar with the program and all of the resources and be able to ask relevant questions about that on a regular basis. So they need to understand where the pieces are. If there's a charter for your program, then that needs to be something that they know back and forth. If there's not a charter, maybe this is an opportunity to develop a charter for your program that kind of talks about the four corners of your program. They need to have that annual report. That's baked into the sentencing guidelines. There at least needs to be a state of the state on the compliance program delivered to the full board on an annual basis. If that's not happening, that is not consistent with what the sentencing guideline standards at least expect. They need to be familiar with all the initiatives that are going on. You have new training that's going on. Remember, the case law, Stone versus Ritter, and the guidelines talk about training. They need to understand these big picture pieces of your compliance puzzle. And if there is a all hands annual code of conduct training that's going on, they need to know about it. And they need to have a log on. I'll talk more about that in a few minutes about how important it is that the board be familiar not just with the fact that the training is happening, but they need to be familiar with the tool. They need to be able to ask, how are they going to ask intelligent, relevant questions about the online training for the code of conduct if they haven't seen it? Now, maybe they don't have to go through and complete the whole thing, but they need to have access to the tool and be able to see how this material is being presented to the organization. They need to know all the relevant data. Now, there's obviously a lot of different strands of data that you can go to within your organization, and every organization is going to differ around this. But here's some basic ones. Reporting and investigations. That's been around for a long time. But what I would suggest here is that you take a hard look about what you're able to report to the board. If it's just hotline statistics, but not open door reporting, not reporting to HR or security or a myriad of other potential operational groups in your organization that are collecting information and doing investigations. If it's not aggregate data, you need to sit down and think about how effective that is. If it's just data that happens to be coming in on the hotline, that might not be the whole picture. Training and communication. They, again, need to have very specific information, be able to look at the tool that you're using to train on particularly on your mission critical training, like if you do an annual code of conduct training. Communication efforts. We'll talk more about this later, but the board, if you have an annual communication plan or multi-year communication plan that talks about uh, compliance issues on a regular basis, and you're doing a multimodal type of communication, whether that's video, podcasting, newsletters, or just shooting out emails to managers on a regular basis, whatever it might be, the board needs to be familiar with what that plan is. The monitoring that's going on in the organization, including any piece of the regular internal audit process that might take a look at various pieces of the puzzle. Benchmarking and assessment. If you've undertaken an informal or formal benchmarking process, whether you've done that internally or worked with outside organization, the board needs to be familiar with that. And if there's been evaluation of the compliance program or your compliance risks, if there's been a risk assessment, uh, uh, whether that's just a piece of the puzzle or a much larger enterprise-wide look, the board obviously needs to be familiar with that. And as I already mentioned, I think culture is a piece of the puzzle that's often overlooked. But if you have culture surveys, employee engagement surveys that HR runs, where there are some data around compliance issues such as reporting and retaliation, organizational justice, culture data that's available out there that you've gathered or plan to gather. Those need to be discussions that happen at the board level. As I just mentioned a second ago, online training isn't just for the rank and file. Get them a login for their online training. Let them see what the tool looks like. I will tell you anecdotally, I know this is one area where in the past clients have been reticent, saying, yeah, these members of my board are high-powered executives. They ran their own companies for 30 years. I don't know how they're going to react if I give them a login for training. Well, what I can tell you is I've worked with at least a half a dozen organizations over the last 5 or 6 years, and almost all of them, every organization was a little bit concerned about this. But everyone that did it, everybody that presented it to the board, was really pleased with the results. What they got back was a lot of engagement. And how you present it to the board is as part of this whole process we've been talking about. This is part of their oversight responsibility. You're not giving them a login because you think they need compliance training. That's not how it's presented to them. You present it to them as an opportunity for them to see the tools and see how they operate and how you're trying to reach the various members of your organization and impart this really important information to them. It's mission critical information. And so they need to understand how the system works and have an opportunity to take a look at it and evaluate it. And that's what they're doing. They're evaluating the training. They're not taking required training. They're evaluating the training for the purposes of oversight. And as I said, every organization that's done this, even though there's been some reticence, has been very pleased with the results. Encourage your board to develop that expertise we were talking about. That might mean going out and going to seminars. That might be attending webinars. That might mean going to a conference or joining a newsletter, a regular newsletter that that perhaps SCCE or some other organization provides on compliance. Get them interested in having more touch points that are informal around compliance. Another big piece of the puzzle is training on specific risks. Obviously, we could spend all day talking about specific risks that organizations face. One of the other pieces of guidance from that new DOJ February guidance is focusing on manifested risks, things that have already happened either to your organization specifically or in your neck of the woods. Then there's an expectation that the organization is going to be right on top of those manifested risks and have training and communication and controls in place. So the board also needs to be up to speed on those risks that have manifested either in your organization or in your industry. And that, again, may be things that are facing your peer industry or other industries, not necessarily you yet, but they're on the horizon. Some common issues that are kind of cut across all organizations these days include anti-corruption, data security, privacy, general issues around reputation risks that touch on all three of those. But every organization is different. You have a different risk profile. You have to do a different risk assessment, and so the risks that are going to be trained, the specific risk training that's going to happen at the board of directors is going to vary from organization to organization for sure. Risk specific to serving on a board sometimes will come up in context. Things like conflicts, insider trading, direct liability. These are all things. Conflicts and insider trading, apply to everybody in an organization, but there are some specific risks that you see as a board member that come up more frequently, particularly around conflicts. That you'll often see specific risk training, and I think that's important to consider. So that's another bucket, specific risk training. So the last thing that I wanted to talk about here, and then I wanted to, leave a little bit of time for some questions. And I meant to say at the top too, if you wanted to posit your questions as we were going along, to feel free to do so. But please now you can, if you have some, just start typing them in, and I'll get to them here in a second. But the last piece is this informal piece, and I think that this is important. And this, when we, again, as I said at the top, when you think about training, you think about formal training. You think about what I'm doing right now, doing a presentation to a group of people, having some data, some slides. But I want you to think a little bit more about the informal piece when you're talking about training your board of directors. And it's about a broader relationship beyond training. It's creating a strong relationship with your board on an informal level. And to kind of introduce this, I want to tell you about a couple of organizations I've worked with past and how they handle this. Oftentimes, this will be with the chair of the audit committee of the board of directors, will kind of be the informal contact person. But I've worked with one organization where it's gone beyond that, where there's a group of 3 or 4 directors that have a set phone call every other week with the chief compliance officer of the organization, where they get on the phone and they don't necessarily have a set agenda. They might have 1 or 2 items that they talk about every time, any new investigation of developments, any new reports that have come in. But beyond that, they have an open discussion about initiatives. What's going on? What are the plans for the next quarter for the compliance program? How did that training rollout go? They have an informal but set piece of time for that discussion with the board. Now, these organizations have developed this over the last few years just because it made sense to them. It was something that helped them out a lot. But I would go back to that guidance we were talking about a few minutes ago that just came out from the Department of Justice about executive session. Now, that is very specific language, and that seems to suggest that there ought to be some time carved out of the quarterly meeting of the board of directors where the compliance officer has FaceTime with the full board. I think also you can satisfy that by a strong informal relationship and engaging the board beyond this formalized quarterly meeting where you get 60 minutes, go in, run, and then you're done, and then it's silence again for 3 months. I think many organizations are finding that they can have these informal relationships either with the chair of the audit committee or a broader group that are much more fruitful, and they can get a lot done that frees up that time on a quarterly basis for you to do things that you always wished you could do during that limited space of time, including training that you can't do because you have to provide a lot of other data. But if you can provide things like incident reporting and other data reporting on a more frequent informal basis, then that might free you up on those quarterly meetings to do something a little bit more interesting and a little bit more fruitful. The other thing that that you might consider, and another organization has had some success with this, is engaging the board beyond their traditional role and communicating to your stakeholders about the importance of compliance. Uh, More and more often, it used to never happen, but more and more often over the last few years, I've seen organizations where a member of the board, whether they're the chair of the audit committee or somebody else, has stepped up and has recorded a video or has sent out an email about either a particular issue or about the fact that Compliance Week is going to be happening here in May, or we really want we're going to be rolling out a brand new code of conduct we're all very proud of, including those of us on the board of directors. Whatever the message is, but a message reinforcing the importance of the program, reinforcing compliance, coming from the very top of the organization, can be very powerful, very, very powerful and very helpful. The other thing that I've seen a particular organization's board members do here in the last couple of years is actually communicate externally. Um, uh, there was a board member from a bank who has recently gone out and been speaking at compliance events, on panels talking about the importance of compliance and uh, how he handles and how his organization handles compliance issues at the board level. So, kind of spreading their wings and talking not only to the organization itself, but to the external community about the importance of compliance. It really extends this notion that the board takes this seriously, that it's mission critical and non-negotiable. And that can be an important thing to see happen. I already talked about this. The informal relationship can, involve reviewing cases, looking at initiatives, also engagement around incentives. Getting congratulations from a member of the board of directors for doing something right can be very powerful. So perhaps if you have incentive awards that you already are giving out to members of your organization around compliance initiatives. Maybe a member of the board of directors, the chair of the audit committee, can be the person who actually delivers the award. Maybe if your the chair of your audit committee, maybe she can actually attend an event and hand the award out to the recipient. I think these are things that seem rather simple but can be very powerful. So with all that, last thing I wanted to say is we have plenty more information available on our website at moreheadconsulting.com. You can email me directly or phone me directly if you have specific questions. I'm happy to spend some time talking to you about it. Also, would love for you to check out our podcast at compliancebeat.com if you haven't already. So I'm going to see what questions we have here developed that I might answer here in the last couple of minutes. We have a question about separate codes of conduct, one for officers and directors and one for everyone else. Yes, this is a trend that was more common a few years ago. Obviously, the trend now, as you probably have noted, as you look at other organizations, is that there's one global code of conduct. The other thing that used to happen quite a bit is you'd have regional codes of conduct. You'd have North American code of conduct and Asia Pac, and that's really going away, as is the separate code for directors. This was a response partly also to SOX and making sure that the special responsibilities for financial officers were well documented. But that all can be done in a paragraph or two in a global code of conduct. So obviously the preference is if there's a window there to try to combine those two, that would be I think best practice and certainly what most organizations are doing these days. But if you can't, I think that obviously you have to train the directors to their responsibilities in the director, if there's a separate director's code of conduct, but they also need to know about the code of conduct for all employees and have a solid understanding about that document as well as all the other important written standards. As we were talking about before, there's no distinction made by the department or the sentencing guidelines or any other standards about a code of conduct, one code of conduct or a director's code of conduct or even a code of conduct. It just talks about written standards, the entire universe together. So I think that if you have two of them, you're in the unfortunate position of having to train on both at this point. But it might be an opportunity to bring up to the board of directors that most organizations don't do this anymore. Most organizations have a global code of conduct that everybody buys into, and if it's already something that's been on your radar to maybe revise and update your code of conduct to begin with, it's an opportunity maybe to get that project on burner. Another question is, should the board be provided with the company's compliance materials, and how granular should this get? Copies of all companies' procedures, for example. I don't think so. I think that again, kind of going back to what I was just talking about with written standards, they need to be generally aware of what the universe is. For example, if there's a portal, many organizations in the last few years have developed a compliance portal or a standards portal, procedures portal, where a lot of these materials are available for the rank and file. Certainly they should be familiar with that system and that those materials are available. If there are significant updates that have been made to mission critical policies and procedures, if for example, when you look at your risk assessment, the top three risks for your organization are data security, anti-corruption, and say, let's take some garden variety like harassment. If those are the things that are top line for you as the compliance officer, then they might want to be familiar with a little more familiar with those policies and procedures, training and communication around those issues than they would be the other 50 risks that you face as an organization. What the guidelines expect and what the department expects when they evaluate a program and what you do generally is that you have a risk-based program, right? That's what they've been saying for the last few years. So I would take the same concept when you're determining what you need to present to the board and what you just don't have time to present to them, based on resources. And I would look at your risk profile. What are our top tier risks? If anti-corruption is a top tier risk, if for example, your organization had an issue a few years ago that you resolved, and that's still a top tier risk for you based on your operations, then I think that the expectation is going to be that your board is more familiar with that risk and what you're doing to combat it than a risk that's not a top tier risk. So in that case, maybe they're going to be a little bit more granular and have more expertise and knowledge and training around that particular issue, what the written standards are, what the procedures are, what the informal communication and the formal training looks like. So I think that's the way you slice and dice it. You have a limited amount of time where you can impart information to them. Although, as I just suggested a few minutes ago, if you can capitalize more on some informal time and set up a biweekly or a monthly call with the chair of the audit committee and maybe a few other stray directors that are interested, you can cover more ground that way. But ultimately, you're going to be making some tough choices, I think, on what gets presented and what doesn't. And a lot of that is going to be based on your risk profile, and you're just going to have to make a decision based on that. And it's like everything else that you're going to do with your program. If you take a risk-based approach, that's defendable. If anybody ever questions you, you're going to say, look, we didn't train on export control because we didn't recognize that we had an export control risk, because we had just acquired this subsidiary and we didn't know that the risk existed, so we didn't train the board on that last year. Now we're going to, because we recognize it as a risk. I mean, you just have to have a narrative. You have to have a story that you're able to tell as to why you've made the choices you've made. I think the main thing you want to combat here is not doing anything out of a fear of being too much out there to potentially cover. You're just going to have to try to make headway as you can, particularly if this has not been part of the formal communication with the board in the past, doing training and spending that much time with the full board on these issues. It's going to be hard, and it's going to be incremental probably as well. And you're going to have to fight for every minute, and it's going to be a process. But I think you just have to build on it as much as you move along, and be able to justify your process as you move along. So if there aren't any other questions, I just want to thank you all so much for joining me this afternoon on this. And as I said, if there are any other questions you just didn't want to bring up right now, or if something comes up later, please feel free to email me. My email address is right here on the screen, or give me a call. I'm happy to spend some time talking over issues with you if you have a couple of questions. And thanks again for joining us, and look forward to seeing you again when we're going to set up some webinars later in the summer, and we'll be in touch. Thank you.